None of that is in the actual wording of the ruling. The wording of the ruling actually has very little to do with the free speech aspect. It only adjudicates on one claim.
I'm going to read this. We are going to read this. Defendants, and defendants being the government, correct? And their agents, and all those acting in concert with them, are permanently enjoined from implementing, instituting, maintaining, or giving effect to freeze orders and termination letters, or any conditions imposed therein, from issuing further terminations, freezes, stop work orders, refusals to award grants or contracts, or withholding of funding from Harvard in retaliation for the exercise of First Amendment rights on their purported grounds of discrimination without compliance for Title V. What the fuck are you talking about? It directly says they're permanently enjoining the fucking defendants, the government, from issuing grants or termination letters on the specific basis of Harvard exercising its First Amendment rights. You actual fucking disgusting liar. Hi guys, thank you for watching this video. Make sure to like and subscribe if you want to see any future content. Also, make sure to follow my socials in the description. And if you want to debate sometime, just add me on TikTok and send me a DM. Thank you. Yes, Daddy.
So I'm actually looking at the ruling, and it doesn't say anything that you said. Where did you read the ruling? Did you actually? Better question, because I know you and your brother did this. Did you actually read the ruling, or did you hear about it elsewhere? So before you Google it, how many points? Before you Google it, how many points are made?
So there's actually two cases. So which case are you looking at, and what's called?
So the specific case would be in the United States District Court for the Districts of Massachusetts, Presidents and Fellowships of Harvard College. It's the plaintiffs versus the United States Department of Health and Human Services et al. As the defendants. It is case number 1.25CV11048AB. And it is the order and adjudication declared as follows.
So there's two cases. So there's one involving the SEVP certification, if I'm correct, and then the other case is specifically involving the grants that were taken away, and then those.
Yeah, it was specifically about the grants, and that's the only one that's had a class order against it. The other one didn't even get a final judgment. They had an order to stay, which means that a final judgment on the first case has never been made. So if you read it, how many points are in that?
So
if you read it, how many points were they? I know you're trying to buy time to Google it.
So we're talking.
Yo, stop steamrolling the host.
I'm not googling anything. I'm playing Java.
Yeah, I can hear you.
I'm not googling anything.
Sure. So tell me what the conclusion was from that order.
Can I finish? Okay.
You can tell me what it is.
So what the order was saying, right, and what the court came to determination was that the grants were taken away, were a violation of Harvard's First Amendment rights, and then they asked for a reinstatement of those grants, and then they stayed it because the government said they were going to appeal the case.
This is what happens when you get political pundits trying to read law. You're a complete idiot, because that's nothing. None of that is in the actual wording of the ruling. The wording of the ruling actually has very little to do with the free speech aspect. It only adjudicates on one claim. So the argument that they adjudicated on was whether President Trump had the right, and the United States Department had the right, in the evidence that they presented, to make any concessionary claim, which is why it's going through the appeals. It actually very little of the focus was given to the free speech. The reason being is the standard of proof for the burden of free speech doesn't fall on Harvard in this case. It will in the appeals courts, but not in this court. So what they actually argued was that Harvard went, and they said that the evidence provided by the presidency and provided by the U.S. State Department was insufficient enough insofar as the procedure that it claims to be following, which is true. It's now being appealed. Okay? That is what it is stating. It only cursorily mentions free speech. I'm literally looking at it right now.
So I've looked at it in the past, so could we just cite exactly where you're saying that?
It's in the accordance with the court memorandum ordered dated September 3rd. Did you read that one, or did you just read the cursory conclusions made after, which is just a compilation of what was discussed? That would be like 5 points.
So how does this mean it's not about free speech anyway? It still is.
Because it wasn't. This ruling is not about free speech. This court didn't say, "Oh yeah, President Trump is violating free speech laws." They don't have the authority to do that in this case.
So
that would be a Supreme Court level.
As a critical thinker, I can't still look at the case and say that they're trying to suppress free speech. I have to listen to what the court says.
Well, you can't say that the court has ruled on it, which is exactly what Scratch did. So nice try to manipulate. You're doing exactly what you're still doing a great. You're still doing a great impression of what you claim it is.
Okay, so here we can so in case of course raise complicated important legal issues, but at its core it concerns the future of grants sponsoring research that promises to benefit significantly the health and welfare of our country and the world the government's statements and actions, the fate that of that research has now been intertwined with the issue of anti-Semitism at Harvard. Anti-Semitism, like other types of discrimination or prejudice, is intolerable and is clear, even based solely on Harvard's own admissions, that Harvard has been plagued with anti-Semitism in recent years.
From?
I'm reading from the conclusion of the same order. Recent years.
Wait, you're reading from the conclusions. You're reading Alison D. Burroughs' conclusion.
Yes.
This isn't her conclusion. 3rd. I'm looking. That's not her conclusion. That's the conclusion on one part of the proceedings. You don't know anything about law, do you?
This is the summary judgment, the one from September 3rd, dumbass.
The summary judgment is not the finalized judgment.
What do you think
she's
they're
summarizing? No. This is where ignorance to law really doesn't give you a defense. No. They're not asking. You're dealing with some of the most complicated legal questions. A summary judgment in this case would be what the judge is doing in this case, what Alison is doing in this case. She's going over cursory arguments that are being made and their relevance to the case. So she's making a summary judgment on the relevance. So it's in summary. That's not the final judgment.
I never said it was the final judgment.
So why are you not reading the final judgment, which gives the clear indication that it's not about free speech and it talks about specifically what is addressing?
Okay, so can I just share my screen real quick? Here, let me show this.
By all means.
This is on court listener, right? So this is the summary judgment of September 3rd, correct?
That's her statement. What did she file?
Right?
That's her statement. What did she file?
Like, what's the order?
Statements. Yeah, the actual order. Statements.
The order's right here.
Held. So what was the order? Because So when she said
order, this right here.
In order, a judgment and decreed, what was as follows? What are the 5 points?
This is what you're looking at right here. This order.
It's 5 points. That's
so you're saying there's not
order entering final judgment. Go to that. The date is very clear. It's on the 29th. No, sorry, it's on the 20th of October. It's the final judgment. On the 17th of October, you had the joint status report, the order of motion to stay on the 9th, and then you had the defendant's motion to stay on the 8th. You had the order of motion for stay on the 2nd, then you had the defendant's motion to stay on the 1st of October. Then you have the scheduling order and joint status report.
There's nothing on the wait, what are you talking about? Everything ends at the October 9th.
Oh my God,
what are you talking? I'm on court listener right now. There's no second page.
So court listener is not the only place you get it. To
yeah,
get
obviously
a cursory judgment.
You can look at pages.
Maybe stop talking. Maybe stop talking. This is the finalized judgment of the case. Oh, sorry. This is the plaintiff's unappointed motion for stay in regards to bills because they're anticipating appeals. So this would be the final order, the order entering final judgment. This is what you'd be looking for. Okay? If you don't have this, bearing in mind, it is dated the 29th of 2025. You're not looking at the final order, which means you haven't read it. So why are you trying to comment on a case A, you've not clearly looked into the facts into, B, you have no understanding of, and C,
the last thing filed is in October 9th. The last thing filed was on October 9th.
So where does it say order entering file judgment? Is there anything there that says it? Yes or no?
There's nothing that says there's a summary judgment.
So you're looking at a summary judgment, not order entering final judgment.
You're probably looking at the other case, dude.
Or maybe I'm looking at the actual case, and you're just looking at a website you think lawyers use.
No, lawyers use Pacer.
Are you on the United States District Court for the District of Massachusetts? Yes or no?
No, I'm a court listener. You understand there's two different...
Why are you not on the State Department's website, which has all the filings and proceedings?
Are you...
You fucking idiot. Jesus Christ.
Because
where do you think you get court documents from?
Are you serious? You understand that court listeners...
I don't give a fuck about court listeners. You would get the final motion... you would get the final motion from the state of Massachusetts, wouldn't you?
Yeah, and guess what court listener does when it's a final motion?
State of Massachusetts. Well, they don't have the final motion. You just
there's two different cases.
You've just confirmed. I'm not confused. I'm not confused.
No, you're confused.
Okay, so when it says, triple check for me, is it Alison D. Burroughs presiding over both cases, or is she only presiding over one?
She's presiding over this one, Allison D. Burrow.
Yeah. So when I'm talking about the exact same case as you, and you're saying you're thinking of the different case because you think you understand the law.
Yes,
because
there's
you go
two
to
cases.
one
There's
website,
two cases. Yes, there's two
she
cases
doesn't. She doesn't preside over both. You idiot. So we're on about the same case. You've just never looked for the final motion.
The final motion will be posted on.
You're doing allegedly what you accuse Mideast Peace of.
Can you finish?
How about you go and look for
That's
the
not
final
what I
motion?
accuse. That's not actually what I accuse Mideast Peace of
Being
doing.
dishonest, arguing in bad faith. That's exactly
No,
what you're
that's
doing
not
here.
that's not what I accuse.
Go
Mideast
and
Peace
search
doing.
for the order entering final judgment, which will be on the 29th of October, and it is by Allison D. Burrows. She's the court judge presiding over this case.
You're clearly not a lawyer because you both got it wrong, but whatever.
Go ahead, True. If you think you got it right, go ahead.
Sure. The motion for summary judgment, you have the memorandum, right? The memorandum lays out the legal arguments and legal conclusions that she makes, right? Once you have a motion for summary judgment that is entered, right, then the parties at some point need to move for a final judgment, right? So what you're looking at, Ido, whatever your name is, on the 20th is the final judgment, but it's also based on the information and the legal conclusions that she found in the September one, which is the memorandum and the motion for summary judgment, which was denied in part and granted in part. And you're right, she denied the portion on the First Amendment part, but that doesn't end it. It just means that under
No,
this,
I agree. That's what I said.
Under the motion, but see, you're both wrong though. At this
No,
point,
we're not both wrong. I've been telling him just to go to
let
the
him
final
finish.
judgment. No, because
is-
he's right in what he's saying. But I said this earlier in the discussion, and that's why I told him to go to the final judgment in this case, and then you can look at how they're appealing it, because neither side would be appealing on the First Amendment claim here. That's the
They
important
could
part.
actually, they could because
I doubt it.
They can if they wanted to. I haven't looked into how they appealed it, but you can.
Neither side has.
If Harvard wanted to, they could appeal that portion of it because
They
it was
haven't.
denied.
They
Well, I
haven't.
don't know if
That's
they
the
have or
point.
have not. But
I know they haven't. I'm looking at the appeals now.
But at the same time, that is not over at all. This is just a summary judgment.
I
right?
agree.
That's exactly what we
True.
said.
That's what I said. You're literally he's arguing a completely different point where he made it about freedom of speech, but that was removed in the final judgment. Now, did you look at her reasoning at all why she removed it? True.
Yeah, she said that there wasn't sufficient evidence for her to figure it out.
But wait,
which
this
is
is the
fine.
Yeah.
So
Exactly
that's what I
what I
said
said.
earlier.
Like I said.
Under summary judgment, the standard is if there's a triable issue of fact, you cannot grant it, right?
Yeah,
So
I
it's
agree.
still at issue, right? It still has to go to trial. They could also try another summary if they wanted to later on. If they wanted to, they
Yeah, sorry, I
probably
might.
would.
Sorry, I might be confused. So these two things right here have different case numbers.
Yes.
From the summary judgment. Okay.
Yes, that's a different case. So the case number that you would be looking for under the Massachusetts district, and
So these
would
are
be-
both understand.
One
These are
second.
both under Massachusetts difference. These are both involving the.
Yeah, they would be both under Massachusetts district.
And they're both.
Why
They're
do you-
both involving Harvard, and they're both involving Allison and Deaver.
But no, the secondary case shouldn't. She might be a sitting presiding, but she
No, it
wouldn't
says
be.
literally. It
she
says
wouldn't be,
right here. I can.
One second.
Zoom in right here. Do you see that?
One second. I've got Peter
see
B.
that?
Hitch preside. I've got Peter B. Hitch presiding as the case judge over the second one. Maybe she was on the first one and got moved over. But on the
That's
final
prob-
motion,
okay,
she's
so
the
it's
only
probably
one
why it's
listed.
confusing because at this point she is presiding.
Laura's confusing. Laura's not made for the faint of heart, as I'm sure True would agree with me.
Okay.
On the
So
case
I don't
number-
wait. I just want to clear. I don't think it's disingenuous of me when there. It seems like there's different facts here, or both of us are confusing the facts because there's judges being reassigned to different cases probably.
Yeah, you need to if you want a good website that'll give you the most up to date, you can go to the litigation tracker, Law Georgetown EDU. They've got it, or you can actually just go to the United States District Court for the District of Massachusetts because they will have it on their website. That's where I got mine from.
And just to give you on any document that's filed in the district court, if you look at any document at the top, will always list the case number with three digits. I mean, three letters. Those are the letters of the judge that's assigned to the case.
Yeah,
So you
ABD
can
in
always
this case.
see ABD on this case.
Okay.
And in this order, you can even look for the document if that's too difficult. In this case, it is document 247 filed the 20th of October, 2025. And then it went into it. So it goes through the process, and then it got finalized as a motion. So it was finally made in written form on the 29th. That's when it was released. So it has to go through a whole process of they have to go through a whole process to get it out. And then you have the termination letter of Department of Commerce as well.
Can we not argue all the legalese and maybe just talk about the heart of what's at the matter here?
Yeah, but his point is it's about free speech. That was yours and his contention. It's not. The
Okay,
final judgment at this point is not.
If that's what the final judgment is, I'll concede the point then. That's fine.
You can always be appealed.
Yeah,
It
it
is
can be
legal.
Well,
appealed.
it's not. It isn't appealed, and the appeal court hasn't made a ruling, so I'm just gonna concede the point.
No,
And
it had that. An appeal has been submitted from both Harvard and from the United States Department of Health and Human Services. So they've both appealed, but on different grounds. Neither are appealing on human rights grounds. The grounds that Harvard is currently appealing on is they in the first part of the case, they waived a partial right to compensation for the time lost of the payments. They're now appealing to try and reclaim it back in terms of resourcing. So instead of giving the payment out, they get allocated a certain portion of research and resources for research instead of a payment to try and reclaim what they lost in the medical field. That's what they're appealing on the judgment for, because that was rejected, even though it's technically legal. And US is appealing on the fact that they shouldn't have to give this organization money, especially when it violates its own terms of services and US law, because their argument is a lot of the arguments that have been made at these Harvard protests that Harvard failed to deal with are direct violations of statutes that preside over counterterrorism. So that's why they're not doing the free speech avenue. In fact, Allison did them a massive favor by not letting it go down this free speech round, because if it did, then it could really boil over into some really sticky situations where you start having Harvard arguing against counter-terrorist laws, and if evidence is presented that they did nothing in regards to people acting or at least endorsing terrorism, then that could seriously impact Harvard's both reputation and other effects. So it could lose even more funding.
What terrorism did Harvard support?
It's inaction against it. There were several people who were a part of the protests who were claiming support for Hamas and Hezbollah and even the IRGC. Now, although the IRGC is not itself considered a mainstay terrorist organization, both Hamas and Hezbollah are listed as terror organizations in the United States, and you are prevented or not allowed to voice support for them. And Harvard did not expel these students or did not go through their own conduct in order to get rid of them.
I asked you what terrorism did they support?
I gave you the answer: Hamas and Hezbollah, terrorist organizations.
So in America, I know you guys are losing it over there, but we have freedom of speech to say they support Hamas.
No, you don't.
So there was an
I
executive
support
order.
Hamas.
Okay.
Call the FBI.
Yeah,
There
we
was,
have that right.
Hold on. You do have that right.
Wait.
But what was signed in, which hasn't been yet, it hasn't been tried in court yet, so we don't know where it's going to fall, is that on, I think it was January 29th, 2025, Donald Trump signed an executive order that broadened the definition of what support for a a terrorist organization
just say
means.
terrorist.
Yeah, he can't do that.
I'm sorry. I'm on.
It
Actually,
has,
he can.
it has not
No,
been.
he can't.
Yes, he
It
can.
has not been.
Wait, this is litigation
Tried
tracker. The only thing I'm seeing is the October 2nd summary judgment, and then the
So if you go,
one on the
wait, it literally
first
says at the O'Neill Institute at the top with litigation tracker, last updated October 31st, 2025, and it gives you the district court, which is Massachusetts. The goal: block enforcement of an agency's action, declared that the agency's action is unlawful. It gives you the issue, which is federal health funding, why it matters, potential impact. And then if you just scroll down under the news and news analyst, it gives you 63 major filings. And it gives you the final major filing, which is the order of motion to stay, which is only to do with Harvard saying to waive effectively paying the bills after 14 days after the end of the case, just in case of appeals. And then the final judgment, which is on the 20th of October, 2025, which is titled Judgment.
So just so
I'm literally looking at it right
Truth
now.
understands in Tumblr, what the executive order didn't do is it's not saying you can't say that you support terrorism. You're allowed to say that you support whatever you want. What it did was it broadened the definition of what material support could be. So in the
Well,
past, where it was you have to show that you are actually providing funds to the organization, that now basically broadened it so that you could have in-kind contributions such as passing out pamphlets that would materially support or have directly come from that terrorist organization to be
yeah,
included.
no, if it's codified in the law, if I'm sure there's a definition, because I know I looked at one point and looked this up. If there's a definition of what material support is, the president can't just simply say, well, I think it is this now.
Correct. So once that's challenged, it's going to be thrown out because I could just go hand out
Well,
pamphlets for
it
the.
hasn't
Can
been
I
challenged
finish?
yet.
Can I finish? I'm allowed to go hand out pamphlets in support of HTS and the Taliban because we're a state sponsor of terrorism in that aspect, but just not Palestinians
So
and
Tumblr,
Hamas.
you are
No,
no
the
Tumblr.
Taliban is
No
restricted.
Tumblr. What you're allowed to do is you're allowed to go and make your own. Let's just call it pamphlets saying this is why we should support Al-Q. But what you're not allowed to do is have something given to you by Al-Q and
Right,
hand
that's
that out on their
actionable
behalf.
speech. That's actionable. That's different. That's a Supreme Court precedent. So he didn't do anything new.
What he did was is he broadened what that might be. So
Yeah.
for
So
example,
if
you
he's going,
had so hold on. So for example, the guy that was in question, I forget his name now. Somebody help me out here. The guy that was at Mamdani's thing. There's a whole.
Which one?
The guy who was about to
I don't
get
remember his
deported.
name.
The one from Harvard, or the one
No,
from Brown?
I think it's the
no,
one from
the guy who's
Columbia.
getting deported.
It's
What the hell was his name? His wife was here. He's from Syria. Can't remember his fucking name.
Mahmoud Khalil.
Yeah,
Mahmoud
Khalil.
Khalil. Yeah, there you go.
Yeah. So Khalil was handing out documentation that literally came from Hamas.
No, he wasn't.
So
That's how the government
yes, he
handled it.
was.
No, he wasn't.
He was. He was.
They didn't prove that in court. They didn't have the evidence.
Well, it hasn't been challenged yet. It's going to be.
I'm gonna pull up the court document.
It hasn't been.
This
challenged in
hasn't been
court.
challenged yet.
So you can't pull
He
something up
was
that
getting
hasn't
deported.
happened
He
yet.
was going to be deported
Can I
for different
please
reasons.
explain what
That's
I'm
not
saying
what they
before
were
you both
deporting him
jump
on.
I didn't say anything about a court, did I?
You did. You said you're going to pull up the court documents. No?
That's literally what you said. If you're gonna lie better.
Okay, wait.
Suni, you're not very smart.
Okay.
I'm
I
not
don't worry
what?
for all the
Very
reasons
smart.
stated in the for all the
Just
reasons
not
stated
very
in this
smart.
court, September 3rd, 2024 memorandum, EFC memorandum.
Nothing happened
incorporated.
though. I have no. There's no
Hereby
deportation
ordered,
case.
adjudged,
None of that
and
happened.
decreed as follows. Judgment is entered for plaintiffs on its claims. So the plaintiff in this
Wild.
case is obviously the presidents and fellowships of the college. So judgment is entered for the plaintiffs on its claims under the Administration's Procedure Act for violations of the
This is
First Amendment
crazy.
to the Constitution of the United States
Scratch,
and
you gotta take control of your life, bro.
Article of the Civil Rights acted in 1964. Judgment is also entered for the plaintiff on its claims under the Administrative Procedures Act insofar as they challenged the April 14th and May 5th, 2025 freeze orders as arbitrary and capricious. Judgment is entered for defendants as set forth in the memorandum and order on the plaintiff's ultra vires claims and on its claims under the Administration Procedure Act that the termination letters are arbitrary and capricious for lack of subject matter jurisdiction. The freeze order and termination letters are vacated and set aside as set forth in the memorandum order. Defendants, their agents, and all
What is
those
that?
acting
I'm
in
sorry. What does that say
concert-
on my screen? I'm sorry.
What are you trying to pick apart here?
It seems like they're saying that they're declared to violate the First Amendment.
No,
Right
the
here.
freeze order and termination letters are vacated and set aside as set
What-
forth in the
okay.
memorandum and order.
What does that
So
say?
once again,
then?
what are you looking at?
What does that say?
You're
This
not
is-
looking at the same document as me, are you? Yet again.
Okay, well, this is an order from District of Massachusetts. Okay, this is from Judge Allison. Is correct? Yeah. Okay, this is from Judge
Are
Allison
you
D.
are you
Burgess.
literally So once again, where are you getting this from? Because I'm looking at the actual court document, and it doesn't look to have the court document
What do you
stamps. It
think
doesn't
that
look to have
is?
anything.
Is this the court document? Am I
Holy
going to
shit.
say it? Is this the actual court document? Am I going to say it? Am I not looking
I'm
at that?
looking at the actual. I'm looking at the actual.
What do you
court
think
document.
I'm
That's
looking
what
at,
I'm reading
dumbass?
from.
What do you think I'm looking
I
at?
don't know. It could be something
Yeah, go ahead.
anybody
Zoom
may
on the
know.
case number.
But
Zoom on the number.
this is the actual court
Annoying?
document as filed.
Annoying. What do you? Yeah, annoying. Yes, annoying.
No, can you use? Okay, go on first page. Zoom on the case number.
Oh, this looks nice.
Yeah, I'm literally on that case. That's a different case number. Look, that's a different case number.
Go to the top.
Look, I'm looking at the case
Okay,
right now. I'm at
148.
the top. It's a different case number.
Okay.
It's 11048. Jeez Louise. And this is the final judgment. Jeez. The freeze order and termination letters are vacated and set aside as set forth in the memorandum and orders. Defendants, their agents, and those acting in concert with them are permanently enjoined from implementing, instituting, maintaining, or giving effect to the freeze order and termination letters or any conditions opposed therein, and from
Okay, this is the
issuing
one he's looking
further
at.
termination, freezes, stop work orders, refusals to award grants or contracts, or withholding funding from Harvard. So this was just purely on that basis, okay? And then the court expressed reserved jurisdiction over the issue of attorneys' fees and costs and all that.
Freeze and ornament and break it less set forth in the memorandum.
Reread paragraph number one.
Okay, it says this. Judgment is entered for the plaintiffs on its claims under the Administrative Protection
First
Act
Amendment, yeah.
for the violation of the First Amendment. It says First Amendment. It says First Amendment.
It does
Can
say
you read
First
into
Amendment.
the-
It is talking about First Amendment. This is the same case, dumbass.
I just
What is this?
read through.
This is it right here.
Dude, you're meant to be a lawyer, right?
This is the First
No,
Amendment.
True.
I know,
saying
so
it's
So
wrong.
what is this first part doing here?
Scratch, can you read that to me?
Reread paragraph
It says,
number one.
okay, judgment is entered
So
for
it's not-
plaintiffs
it's
on
not-
claims
it's not
under.
paragraph number one. Stop talking. You're meant to be a lawyer, so you claim.
Yo,
true.
this is his live. Shut
Yeah,
the fuck
so
up.
I
judgment,
don't
judge,
give a
he
shit.
asked.
I don't give a flying
it'll-
fucking shit.
It'll be calm down, dude.
You're meant to claim.
Judgment,
No,
judgment.
I'm not gonna have a guy lie.
So I'm not
Stop
lying. Nobody's
talking.
lying. So okay, I'm kind of.
Scratch,
I'm kind
did I say you,
Shut
or was
the
I
fuck
addressing
up.
true?
Please
Was I
shut the fuck
addressing
up.
you, or was I?
Nobody cares, dude.
Thank God.
Okay.
Wait, I thought.
Sorry. Okay, I'm starting to piece
Wait, I
together.
thought-
I'm sorry. I'm starting to piece together what's happening. Okay, I'm starting to piece together what's happening here. And the fact is, I don't know why it was being so fucking aggressive and mean to everybody for no reason this entire time.
Not being aggressive or
No,
mean.
you were.
I just,
No, you were. You didn't
don't
know.
deal with
No, you
liars.
didn't. You didn't know that I was talking. Okay, so I was talking. Sorry. I made a mistake. I was talking
From
about.
ignorance.
I was talking.
From
I was.
ignorance.
I was wrong. I'm missing. I was talking about
yeah, you
president
were
and
wrong, and you were talking
president
from
of Fellows
ignorance.
of Harvard College via United States Department of Homeland Security, in which there's only been a summary judgment, right? There hasn't been a final overruling on this, right? Sorry. Ito was wrong because he didn't understand that this judge, Allison, was assigned to multiple cases. So when I asked him about that, he only said that there was one, which created further confusion. On top of that, this judge is actually assigned to 3 cases, all involving Harvard. This one's actually AUP. This technically involves Harvard, right? All involving Harvard. The reason there's confusion here is because there's one judge. They're assigned to 3 different cases, and all these cases have to somewhat do with First Amendment violations by the Trump administration. That's why there's confusion. Okay,
Wonderful.
sorry.
We cleared that up ages ago. True, you said you were a lawyer.
Yeah, but you were
correct?
being an asshole and acting like I was
Yeah,
like super
yeah,
duper
because
duper
I
wrong. But you were
evidently
also,
showed
but
the
you were just as
screen.
confused. You were just
I
as confused and
evidently
wrong
showed
as
the
everybody
screen.
else.
I wasn't just as confused
Yes,
as
you didn't know this judge was assigned to multiple
excuse me,
cases, dumbass.
excuse
You
me,
were.
Excuse me. Evidently, she wasn't assigned to the initial cases that you were talking about in the same capacity that you expressed. You asked about only 2 cases, you found out there were 3. In the 2 cases that I was aware of that are being adjudicated on, specifically on the Harvard funding, she is only a judge on 1 of them. So when we're sticking to the same topic, no, I was most certainly not wrong. You just like to muddy the waters. Now, true.
That is
tell me
not
what
true.
this
You
paragraph-
never claimed
Stop
there to be
talking.
3 cases.
Stop
I said there were
fucking
2 that
talking.
involved
I
it.
never
Okay.
claimed. Yeah, I never claimed there were 3 cases because you're adding an
Yeah,
additional
exactly.
case
So
by
you
Allison.
were confused, and you
You're
said there only
adding
she
an
was always tied to
additional
1.
case by Allison that is not specifically to do with the funding.
Yes, I was saying the reason
We are
there's
talking about the funding.
You didn't Ido. Okay, Ido. So Ido doesn't understand.
We are
so
talking about.
initially what happened is that there's two cases. He said Allison's only signed to one. I said Allison was assigned to two. So we must be talking about the same case. That was the thing that Ido got wrong. I just discovered there's actually three cases.
Stop lying.
There's actually three cases that this judge is also assigned to. I'm not lying about anything.
Yes, you are.
What? No, I'm not.
That's why your boy is trying to play the mute game. So let's be fucking clear. We started this conversation talking about what, Scratch?
First Amendment violations.
Letting this dude talk to you like
As adjudicated by what and for what reason?
Adjudicated because of the grants.
Okay, so there's two cases involving the grant, only one of which is dealing with the free speech aspect, correct?
They're both, from my understanding, these are both actually involved the free speech aspect. This one talks about the first. Yes, they do. Because look, we can look over it right here. Sorry, give me a sec. Let me find it.
If free speech is mentioned in the case, it does not mean it is the totality of the case. It just
I never
means
said
an
that.
argument
No,
being
wait.
presented.
You just said
the
involved,
one that is
so you're changing the goalpost now, 'cause you
adjudicating,
just-
the
Ido,
one that is
Ido, you're changing
adjudicating
the
on
goalpost.
free speech. I'm
so
not.
You just moved the goalpost.
I'm not. You just don't understand law.
You just moved the goalpost.
That's the problem.
You literally said,
no,
do they
no.
involve
It's
free
not
speech?
moving
Yes, they
the
do.
goal.
And now
That's
you're
not what I
saying,
said.
but they don't exclusively involve. You're changing the goalpost.
No,
now.
I'm not changing the
did.
goalpost. If you are dealing with a murder case and somebody brings up
You said
sexual
First Amendment
violence,
was not
it is
around.
now
Wow.
not a sexual violence case,
Ido.
and it's not what's being adjudicated
Ido,
on, is it?
you were wrong. It's not that hard. I admitted to being wrong. You were also wrong and
Why
confused.
are you being disingenuous?
I'm
I was
not
never
being
confused in
disingenuous.
this. When he came up and corrected, did I not also state that I had already stated?
Get off my panel.
Thank God. Inshallah.
Thank God.
Can he not, like, is it that hard for somebody to admit they were wrong in a conversation? Holy shit.
Dude, I have to give you a rare Scratch win.
Oh my God.
Save that energy for the pro pallies, not for the people who
When I'm
actually know
not
what they're talking
wrong,
about.
I'm not going to admit to things that I've not done wrong. When you lie and do the exact same
I
thing
didn't
you
lie
complain
about-
Mideast did to you, you're a pussy bitch. I get it. You're
I
a
didn't
pussy
lie.
bitch. You have to do the exact same thing.
I
Yes,
didn't
you
lie
did.
about anything. No.
Dude, why
Yes,
don't you
you
go
did.
worry about free speech in your
I
own
specified
country?
the two cases. You
I
added a
think there's
third
a
case
difference
in that had
between
nothing to
lying
do.
Ito, I have a question
Not
for you.
having
I have
the
a
full
question.
picture.
Quick
No,
question.
I think there's
Ito.
a difference between somebody being intelligent and knowledgeable in a case in which they can speak about it and somebody actively lying. Now, the first
I don't
paragraph,
think
which
he
I've been trying to
actively
get
lied. I
to,
think he
I
just
do
wasn't
think he
aware.
actively lied. At this point,
He
I do
wasn't
think.
aware.
And true, in the case of paragraph 1, even though it's not a paragraph, seeing as you like legalese so much, what is that paragraph in doing so far?
You know, actually, I was wrong. I went back and looked at the memorandum of decision a little bit closer. Now, the court denied the First Amendment claim on the ultra vires claim, which is mean essentially they went beyond their statutory ability to do so. But on the first claim, the court did grant the First Amendment retaliatory claim. And it's actually, if you look at paragraph number 1 on that order, it actually clearly says that. So I went back and took a look at the memorandum. If you look at memorandum on page 57, right?
Yes.
Actually,
you mean the
says-
claim that the lawyers in which present for the United
No,
States
no. This is
didn't
the order.
argue. Yes,
This is the
yes,
court's
but
order.
This was never an argued point. The
No, it
overall
doesn't
reaching
matter.
part of
Look,
this.
here,
Oh my God.
This was literally the
Clearly
point.
never done civil litigation. No,
Let
it's not
me-
literally the point. You just don't understand what you're talking
Let
about.
me-
because
let
what
me
he's
read it.
arguing
Let him
is there's a
finish.
specific.
Let him
what he's
finish.
arguing is a
Let me
specific.
read
Ito was wrong.
Yeah,
Oh
yeah.
no. Oh no. Okay, go ahead, True.
Okay, let me read it. It says unconstitutional conditions. Mind you, this is the order. Given that Harvard is entitled to summary judgment on its retaliation-based First Amendment claim, the court not need reach Harvard's constitution on other stuff. But the court clearly grants the.
Is this
First
what happens when you
Amendment
get a
claim.
bunch of retards in the same room together?
Oh, he's getting mad.
This was
Oh,
never
no.
adjudicated on. Okay, so let's be very
It clearly
clear.
was. Here,
He's
I'm
getting
showing-
really
Argued by
mad.
either side.
The lawyer is saying
This,
you're
yeah,
wrong. dude.
I kind of hate liars. So this was never argued against by the United States and their lawyers. They never argued against this point, so it's evidently not something that's in contention.
Discussion.
So we only
First
talk about
Amendment.
things that are in contention.
Yikes.
It is in contention.
Oh my God! There
Oh,
are several
no.
claims in this case.
First
There
Amendment.
are
no.
several. Oh my God! This
Oh,
is
no,
what
I'm
happens when you
sorry,
get
dude.
idiots trying to talk about things. What is the main
Harvard
contention of the First
asserts-
Amendment claim in this case?
Yikes.
Yo,
What is the
Brad,
main
let's just mute
contention
everyone for a
of the
second.
First Amendment claim in this case? True, seeing as you've read it all.
Look,
Can you turn down your
First Amendment
No.
discussion-
Don't try and mislead a U.S. state document because you're illiterate. What is the primary case on the First Amendment
ear
that is
rape.
being addressed?
Oh, Jesus
Holy
Christ.
ear rape. Please. Okay. Don't let him back up here, by the way. You just let True finish.
So he's talking about, so the Harvard made, I think it's a total of 3 claims, right? The first one is the funding. Here it is, the funding
You
decision.
mean because you have to run around and lie about it? I asked a simple
No,
question.
it's
Why
'cause
won't you
you're ear
answer?
rape.
Dude,
It's because
shut
you're
the
ear
fuck
raping.
up.
We're trying to like figure this out. Go ahead.
The funding
That's
decisions.
not me letting him back up. I don't know who it is.
Don't let him back
It
up,
says-
y'all.
Plaintiff, being Harvard, plaintiff collectively challenged his decision to freeze and terminate the grants on 3 primary grounds. So 3 grounds, right? 1, the funding decisions were made in response to Harvard's refusal to capitulate to defendants' content and viewpoint-based demands on its subsequent decision to file a lawsuit in violation of the First Amendment. So that's the first contention they make. So on the discussion portion of this order, the court clearly says, hey, that was a violation of the First Amendment. I mean, it's clearly there. And
That's
here,
not
so-
what the court said. Read the full ordering in this case.
And then the order.
No.
itself-
Read the full ordering in that first point, because that's not what the court said. You're lying. That's why I called you out, because you're a liar.
Order entering final judgment. That's what you were reading earlier, right?
Yes, and in the first part of the final judgment, it doesn't say what you just claimed.
In
Once again,
accordance-
you're
I'm just
jumping
gonna
between
read.
documents and you're trying to link them, which they are linked, true, but they're not saying the same thing because they're addressing 2 fundamentally different parts. There were 4 violations of free speech that were made in these claims, 2 of which were in contention, 1 which was considered null and void because it didn't apply, and the 3rd, which was the one that was accepted in this part, which had
It's
no
because it's saying-
relevance or
so,
holding.
Itto,
And you are bringing up the one that had no relevance or holding that wasn't challenged.
Because it says in accordance with the court's memorandum and order and dated September 3rd, this order is in accordance with the
reading one
summary
part of it.
with the summary judgment made.
And
so
he's
they're
reading
making,
one
so they're,
part
so they're
of it, the
making,
part
so they're-
that wasn't
they're making
contended
these, They're
on.
making these basements off of the First Amendment. That's the
No,
that's
they're
the
making
explicit thing that's saying.
they're making one aspect of it, which is one aspect that wasn't in contention. If this isn't something that's being contended, it's evidently not what the case is about.
Wait, so Itto, what does this say? Right? Sorry, Itto. This is
my
number
God.
4. Defendants and their agents, and all those acting in concert with them, are permanently enjoined from implementing, instituting, maintaining, or giving effect to freeze orders, termination letters, or any conditions imposed therein, and from issuing further termination orders, stop work orders, refusals to grant, to award grants or contracts, or withholding of funding to Harvard in relation for the exercise of their First Amendment rights, or on perpetuated grounds of discrimination.
yeah, what was the claim of what was
Title
the claim that Harvard made?
And that was from the final order.
Wait, no, stop. This part is also not in contention. It is a reiteration of the law, not a condemnation. It is saying that this is the law, therefore don't violate it. It is not saying that there is a guilty party in this respect. You are ignorant to reading legal documents,
All
and
right,
you've got
so when
a
it
further
says-
ignoramus trying
when
to
it
manipulate on it.
So now I'm just going to read this to you, and you tell me what it says, what it means, okay?
I literally
Yeah,
read it
okay.
out loud in
So
verbatim.
you know, the reason
Yeah,
the
I
court,
know.
the reason the court, could be clear, the court doesn't
Let's-
just
let's-
say, the court doesn't just say shit to say shit. They're saying this
Right.
because they've determined, right? They've determined that the administration previous to this has issued termination letters that have impeded on the First Amendment rights of Harvard, which they
that's
reiterated,
not what the
in their
claim
summary
is.
judgment,
Oh my
right?
God.
Which is why it says in accordance with the court's memorandum in order dated September 3rd, 25, at the start of the thing. This is like so obvious. The court wouldn't just randomly say this is the law. They're saying it with specific intention.
it's so obvious to you with all your experience in law, isn't it, Scratch? And
I
so
mean,
obvious to
the
this plebeian
lawyer
next
also
to me.
agrees with me in this case.
He's
Just
not a
wanted to
lawyer
point that
by
out.
he's not a lawyer by
Yield to
any
authority,
stretch. Wait, he's not a lawyer by any stretch because he would be able to tell you immediately the first
It is.
paragraph is
You're
in
wrong.
summary.
My-
The first
my
paragraph
brother,
is in
you know,
summary, and he tried to
you know,
make it as a case argument.
You're wrong.
I'm
you know,
not though. I'm not though.
know.
I'm just familiar with the case.
Look. I have this
All right.
problem.
I get it that you and your brother like to play these
you know,
games, but then
you
you
know,
can play when other people do
I
it.
have this problem with Noah all the time where like we're talking about legal stuff and he's Jewish and he's like, oh, I know everything because I'm Jewish, but you don't need to like pretend you know everything here.
No, I
Can we
actually
just-
studied the law and followed this case from inception.
Hey!
So unlike you, I know what I'm
Can
talking
we just
about.
read the order? Let's just read the order.
Yeah, I
together.
read the order
Okay.
in full. We don't need to reread what I
Okay.
already
All right.
read.
So when it
Hey,
says
Scratch, what does them
judgment,
being Jewish
I
have
also
to
know
do
a
with
lot about
anything?
banking
Huh?
because of it, so.
It's a judgment.
So if it's saying judgment is entered, what does that mean? It's not
Judgment
given
is
the
entered.
judge.
What
It's
does that
not
have to
given
do
the
with
judgment
anything?
here.
judgment, the court
What
is
does it have
giving
to do with
judgment, right?
anything?
To who? For plaintiff, right? Judgment is entered for plaintiff, right? On the claim under the Administrative Procedures Act for violation of the First Amendment.
So what does that
In
mean?
of
No,
the
let's stop. You're such a lawyer. What does that stop? What are they? If it's just a plain violation, why are they saying Administrative Procedure Act? What is referred to here? What is the
Because-
thing that wasn't in contention at all in the entire case that necessitates this?
Okay, so the way they
Do you
apply
know?
Yo, Cringy,
Do you
I would get
know?
your money back, man.
You need to let him answer so you can find out if he knows.
No, I know he doesn't. I don't need to let him answer. You can smell it. It's
Cringy,
like
did you get a
smelling
refund?
somebody with stolen
really,
valor
for
a
sure,
mile
bro.
away.
I know things before they say it. Yeah, for sure, dude. Yeah,
When he's
Cringy,
evidently been
cringy,
repeating the
cringy.
same ignorant
For sure.
cursory reading, yeah,
Cringy,
I
did
know.
you get a refund?
So the Administrative
What?
Procedures Act,
Did
the
you
way
get a
it was
refund?
implemented and abused against Harvard was in violation of the First Amendment because it's retaliatory. That's what the court found.
So that's not what the court found. The court's finding on violations of the First Amendment, which they were very clear, was in specific to Harvard professors and or alumni in defense of the protests. That was a court-argued case. There was a part of the aspect which was driven in. This is the violation of freedom of speech, because some of those were also removed from certain programs and procedures, so it was targeted. Nobody contended that. That was a violation of the First Amendment on an individual part. That was argued for by Harvard. The express case of First Amendment right violations in this entire thing would have always been passed up a higher court purely on two simple bases. One, the new legislation that Trump is trying to push through the courts, and two, his actual order in the changing of definitions of what material support for terrorism is. That cannot be made simply on a judgment by her, and she already specified this. So no, the First Amendment violations in this entire case was not addressed in total. It was
Okay,
only
so-
one aspect,
Ido, why
which
would
is
they
what I
say-
said from the
It's a bunch
beginning.
of
So wait,
words.
why would they say they couldn't freeze
Wait,
grants
a bunch
in
of words that address the specificities of it.
Why would answer this question? Why would they say they couldn't freeze grants in the final order if they weren't referring to grants previously?
Okay, so what is the full statement here? Defendants, their agents, and all those acting in concert with are
you answer the
permanently
question?
enjoined. I am answering your question. You're just an ignorant idiot. And permanently enjoined from implementing, instituting, maintaining, or giving effect to the freeze order and termination letters or any condition imposed therein from ensuing further terminations, freezes, stops, working orders, and refusals to award grants or contracts or withholdings of funding.
It says
to
further. It's
Harvard.
implying there's stuff in the past, correct?
So no, it doesn't imply that this stuff. in the
Really? So
past.
if I say, could you?
No,
If
so-
I say
so
no
what- so-
further,
so-
wait.
so-
So Ido, if I say no further murder should continue, am I implying there's past murders that happened?
Is this what the court's implying?
Can
No.
you answer? Can you answer the question? That question.
I am
He already
answering the
said
question, but
no.
you
So that wasn't an answer. So I'm gonna ask the question.
interrupted.
I'm
You
gonna ask the
interrupted
question.
for an ignorant
Yeah.
reason. Let me finish, and I'll get there.
No, you didn't. So I said, if I said there's
Yeah,
no
you
further
did. You literally
No.
interrupted me when I was
No.
explaining it.
No,
Yes.
you didn't answer the question. That's what I said. Okay?
I was in the middle of it, was I not? When you interrupted. Oh, genius! You're so well done. Well done. You're so intelligent.
You didn't
So
answer
to be clear, the reason it states further here is simply because Harvard brought the case, not because anything was found. It would have said this in any of the former judgments, in the conclusions, irregardless. It has to reiterate this point. It has to reiterate this point because it is a
Did you
claim
just
on
use
the First
word
Amendment.
irregardless?
Yes, that's a word.
Why
Is
would the
added
issue?
to
Wait.
the dictionary.
Why would the issue? Why would the issue was stopped for the grants and the
W
funding
Ido,
based on the
W Ido.
based on the
Because
based
the
on the First
claimant is
Amendment
made.
if they haven't found
Because
any
the claimant is
violations
made.
of it?
Because the claimant is made. It's a
Okay, and
reiteration.
if the claim hasn't been found that there were First Amendment violations, what's the point in freezing
No, because this
things on the
court
basis
isn't.
of
This
First
court
Amendment
can't
violations?
fully. This court can't fully adjudicate on this freedom of speech impediment.
Then what?
So
Are
what
they
it's
not?
saying?
Wait, is
So
that
no,
order
they've
not?
only ruled on two aspects of
I'm
it. That's what I've been trying to
asking-
tell you from the
that
beginning.
That order is literally saying to stop these grants and this funding on the and termination.
No,
on basis of it literally says on First Amendment.
the order is saying in total, when when you refer to the entire case that they did not find justifiable grounds that suggest that the government has any reason to actually implement them, and that they are reiterating that any further refusal to give grants cannot be done on a basis to do with the First Amendment.
I want to be very clear what you're saying. You're saying that what they're saying here and what they say further is just in reference because they just happen to come up with a complaint.
Yeah, that's what they do in every single kind of these cases. Go to any First Amendment violations, whether found guilty or not, they do this.
The reason this is a really the reason this is a really dumb, right? This is a really dumb argument is because they're saying it's within an exercise of Harvard's First Amendment. If there wasn't any violations of the First Amendment found, there'd be no reason to stop the grants and determinations in reference to the First Amendment.
It's a restatement because they didn't adjudicate on the First Amendment in totality. They passed it up to a higher court. That was the intention. That's why there's going to be loads of arguments back and forth this. I'm sorry that you don't understand law. Maybe go and pick up a law book and go to Harvard. Maybe you'll learn something. Maybe not, though.
Give me an answer. Why would they freeze it on the basis of the First Amendment if no First Amendment violations have been found?
So now you're misunderstanding the case. They didn't freeze it. What do you think the freeze is in regards to, you fucking idiot?
In Harvard, in retaliation... It says right here, Harvard in retaliation...
Think about what you just fucking said, you idiot.
Harvard in retaliation for the exercise of First Amendment rights on purported grounds of discrimination without complying to Title V.
You just worded it. You just worded it as if the court was freezing something, you
idiot. That's what it says. I read it from the court, dumbass.
The court isn't freezing anything.
Are you dumb?
Oh my god. Who do you think they're addressing? No. Who do you think they're addressing the freeze from, you fucking idiot? The freeze is what the U.S. government fucking did.
No, you're just fucking.
The freeze in funding is what the U.S. government did, you idiot.
Can you read it out? Can you read for the audience, you fucker?
Yes, read. The freeze is from the government.
Read it.
They're addressing the government's freezing, you idiot.
Read it.
So do you think the court is freezing something here?
I'll read it.
Scratch. I get that you're mentally deficient. Do you think that the
I can hear the bottom title rattling in the background,
this.
You're actually being
Can
so
you
dumb.
just answer the question?
Please, every single way, we have to move over to the left side of the fucking bell curve. So fuck your mom, and then move over back to the right side because you're so fucking retarded. I know it's really hard to. Please read the fucking shit on the screen.
The court is freezing in this.
You're bullying.
Yes or no?
Okay, listen, I can't take any more of that, bro.
What the hell was that?
Cringy, why are you laughing like that, bro?
Are you going to answer the simple question, or are you just going to be a little bit?
Obviously, yes, they're freezing the government shit because it's the government. Because the fucking government.
No, that's not how that fucking works.
Oh my god.
Defendants,
no, they're not freezing the government shit. They're addressing the freeze, you idiot.
Enjoined from.
So I'm going to. I can't make it any. Okay, I'll make it a little bit. Okay. I'm gonna read this. We are going to read this. Defendants being the government, correct? And their agents, and all those acting in concert with them, are permanently enjoined from implementing, instituting, maintaining, or giving effect to freeze orders and termination letters, or any conditions imposed therein, from issuing further terminations, freezes, stop work orders, refusals to award grants or contracts, or withholding of funding from Harvard in retaliation for the exercise of First Amendment rights on their purported grounds of discrimination without compliance for Title V. What the fuck are you talking about? It directly says they're permanently enjoining the fucking defendants, the government, from issuing grants or termination letters on the specific basis of Harvard exercising its First Amendment rights. You actual fucking disgusting liar.
So the government isn't freezing, you idiot. The court isn't freezing them. You argue that the court was freezing them.
Look up the nearest bridge. Look up the fucking nearest bridge, and then come back to me, you fucker. Or don't, please.
Why are you being so mean, dude? And listen, Cringy, you need to get a refund, man.
Okay, I don't know if this is a misunderstanding.
I get your uncle butt fucked you a couple of times, but you don't need to be such an idiot and such an
The fucking projection is actually crazy.
Wait, Vader, can you come up here and clear this up? Wait, get Vader's attorney Esquire up here.
He was wrong. He is such a no. First of all, fuck British people.
I enjoy the fact that you're running like a bitch.
The only people are allowed on my panel, and you're British, and you're not considered one of them. So get the fuck off of there. That's the first thing. Holy shit.
Why are you all...
British.
This is the party of love.
Fuck you.
Acceptance, man.
Just to get this clear, you're not arguing that the court is freezing.
You so what's funny is you wouldn't do this on my panel
because
you ain't.
I don't give a fuck.
Wait, I think Wes is trying to say something real quick.
Go ahead,
Hey,
Wes.
Scratch, like you're not arguing that the court frees something specifically, right? Because they are not like the one who are distributing funds or like appropriate, like they are not the guys who are responsible for that specific thing, right? Like you're not arguing that they are freezing, like the court specifically freezing anything, right?
They're stopping. They're permanently enjoining the plaintiffs. Sorry, the defendants,
up,
which is the
guys?
government, from imposing freezes on grants to Harvard in the future.
Okay, I was hearing Ido say that you were saying that. I was just making it clear if that's what you were implying.
Well, the implication, the obvious implication, is what the court says, is that past violations of First Amendment have happened from the government freezing grants to Harvard. So necessarily, that's what it's saying. Otherwise, they wouldn't do the freeze in the first place. No,
Well, Ido's saying that you just changed your argument altogether.
the argument was always on the basis of First Amendment rights violations, on the basis of grants. I never changed the argument. When did I ever say anything else in that?
He's saying
Ido was insanely bad faith, right? First of all, he got shit wrong. I get shit wrong. I actually admitted that as an argument. Second of all, we actually did some investigation and research, and we're all doing it fine, right? And we found out, actually, no, I was right in the first place. Never mind that. Ido got mad because he was fucking wrong.
He said that you said that the court freezed it.
In this specific case, in the other case, yeah, I'm correct.
Wait, when did the court freeze?
It's in
Poutine,
here.
is that you, dude?
Yeah.
Poutine, say something, dog.
Yo, what's going on, guys?
Is Poutine there?
Was that Corbin?
Is that Poutine? Oui, oui. Oh my god.
Wait, Poutine, bro, face reveal finally? Holy shit.
Is that Poutine, man?
He turns on his camera all the time, gang.
Not a Poutine.
No,
Yes, I just do a quick moment.
No,
on
I'm
TikTok,
used
on
to this
TikTok.
guy fucking yelling at like fucking 500 words per minute.
I think you're just very slow.
Okay, no.
Yeah, so here, let me, can you guys see? So this is, in the other court case, because I'm understanding this now better, right here, they do this. Right here.
Let's take a look.
So right here, they are pausing the termination letters and freeze orders. This is in the other case, though, right? To be clear, here's the.
And so your argument was over here on the.
Actually,
first
wait, never
case?
mind. No, that's actually wait. I might be wrong there.
Freezing the termination letters or funds? Okay, like now I'm getting confused.
Ido's saying they didn't freeze it; they just set it aside.
Wait, Scratch, you're uploading this, right? This is content.
Well, no, Cringy going insane in the background, laughing at this poor guy.
I don't know
While
about
Scratch
that.
is just fucking like dropping.
Well, you
some
better
disses.
upload this shit, right? Wait, Scratch, you better fucking upload this.
Huh? I will upload it. Yeah, it is pretty funny.
This is premium
Top tier.
content. This
Top
is funny
tier
as fuck.
content. I don't know, but I did kind of. I said a lot of things. Okay, I said a lot of things. We'll put it that way.
I don't know. I do feel like.
Actually, wait. No, this is the same. No, this is because this is no. They're freezing it right here. Never mind. No, they freeze it.
You might want to reserve your insults.
They're freezing it right here. Never mind. Same case. I was wrong.
I do feel like Ido is a good lawyer. Maybe this was a misunderstanding of the case and specifically which specific things you were arguing each other on. Because I don't know, it feels like you weren't talking about the same thing particularly at some point.
But yeah, because we were confused at the start. That's why, and we were both wrong about different
Is he
cases.
driving?
Okay, I can go down and you can debate him further. So
Okay, I'm not going insane here. The court vacates and sets aside the order, freeze orders as arbitrary and capricious under 5 UC. The court yes, they're doing this right here. I'm not going insane.
You all have about.
So are you going to be honest? Because we weren't talking about this, were we? You
Oh,
were reading
God.
Action 4, weren't you? You were
Yeah,
reading
oh,
Actionable
oh,
4,
oh my
where
God.
you said that the court was freezing. No, they weren't.
Shut up.
You lied.
So,
So why did you crash out? Because you lied. And you got
You know,
wronged.
I think.
I asked you 4 times. Are you saying that the court freezed it? You said yes. No, the courts didn't. The court was talking about the freeze order, which if you look at your recording, you'll find out how much of a dumbass you are, because I literally shouted that at you.
What's this?
Ido, are you?
That's wait, is that a different document than the one you were reading during our argument? Yes.
Yes,
Yes,
same
it is.
court
And
case.
even in
This
that,
feels like
the court is setting
Same
it
court case.
aside. The
Ido,
court
are
is
you in the
setting
Labour
it
Party or what?
aside.
What's the difference between setting it
Because
aside
the
and
Labour
freezing
Party.
it?
Because a freeze in a court means that it is no longer discussable, you idiot. If you are freezing something in a court, it means that it is no longer of the purview of that court to discuss, or they are implementing a temporary block. That is not what they did in that part either. They didn't institute a temporary block.
That makes sense to me.
It's not that serious, man.
Wait,
That
that's
makes
not even
sense to
true.
me, Edo. Wait, how do you reply to that?
Huh?
How do you reply to that, Scratch?
I don't know all the legal jargon. That's what I'm gonna say. That's my reply.
Okay.
It was exactly what I was pointing out. So in this case,
We
they
have an
dealt with
attorney.
one.
Hold on.
In this, I don't care if he says
Edo,
he's an attorney.
Edo,
In this
Edo,
case,
Edo,
in this
hush.
case, they
Edo,
dealt with but one part of the Free Amendment claim, the First Amendment claims.
Edo, we have
and the
someone in the
primary
comments.
contention. I don't care. The
Well, the
Someone in
primary
the comments saying
contention.
you're
primary-
wrong,
the-
I
Edo.
don't care.
to
He
be-
can
to-
say he's wrong.
Well,
The
Edo.
primary
Wait,
contention of this
Josh,
argument
why
is
don't you
still
man?
up for debate. It's going through litigation
guy
still.
has
To be
bar-
clear,
It
to,
has not
to
been
be clear,
finalized.
to be clear, the primary contention to debate is if there's First Amendment violations, and they're saying to stop all future terminations because they found First Amendment violations. That's the future. That's the
They
contention.
didn't
in
say
the
because
case.
they found First Amendment violations. They said because there are alleged First Amendment violations in this part.
that was the final.
Alleged
the
violations
judgment.
versus
That was
finding
the
violations are two different things, because the court even says it can't adjudicate fully on the First Amendment in this case because of cases
On the
presented by Donald J.
Ortavidas
Trump in the
claim.
changing of the definition, because she didn't want to challenge on that. She literally did a whole
No,
speech
you're
on.
wrong. You're just wrong. Shut
Except
up.
I'm not
You're
just wrong. Stop crashing
Go
out.
ahead,
Holy
Drew.
Matt,
Shut up.
Go
I
ahead,
get it
Drew.
that you're an idiot.
Go ahead, True.
Wait, you sound
Yeah,
like a
you
liberal,
want him to go
man.
ahead because he's going to say something that you like instead of the truth.
Edo.
I don't work in the
True
realm
faith,
that you
true
like.
faith. If you just say you're wrong,
can we
you're
get-
wrong,
eh,
you're so
we
wrong.
can't-
Because he is wrong. Look,
Yeah,
So-
but you
Just-
sound
no, just
like
let
a
him go.
liberal, man.
Just let him go.
You sound like a liberal.
Alison D. Burroughs did not say she could not fully adjudicate on the case of the First Amendment prior to the court case initiating. She just said, yeah, I'm going to adjudicate on every aspect of this case. No, obviously she didn't say that.
You
That's
make
why
me
in
wanna kill
several of the
myself.
motions, she said that they would have to be passed up to a higher court if necessary to be challenged. And that is
That's not
exactly
even how
what
it
is happening.
works.
That is exactly what is happening right now.
That's
So,
not even how the
how
court
many
works.
kids?
Wait. Judges can stay on a motion if they don't want to adjudicate on it. This happens all the
They
time.
don't push it up and say, hey,
Yeah, judges
the
push
court,
up things.
you deal with
Judges.
it.
Wait. Judges push things up to the Fifth Circuit all the time. What are you talking about?
So are any of you all watching the Oklahoma
Wait.
Alabama
True.
game tonight?
How many?
What's
Do you
happening?
think that judges have never pushed anything up to the Fifth Circuit?
it's not how it works, but whatever.
That is how it works. They can request the Fifth Circuit to intervene in certain decisions, or the defendants can do that. Like, it's not just one side. What are you talking about?
They didn't do this in this case, Judge. The judge made
Wait,
an
they
order
did. It's literally on the appeal, because she left that door
Yeah,
open.
Because she wrote, "Judgment is entered for plaintiff on this claim."
She
Under the
left
administrative procedure
most of the claims open.
for
That's why it's
violation
being addressed.
of the first. So when she, let me ask you, what does she mean when she says this? Judgment is entered for plaintiff on its claim under the Administrative Procedures Act for violations of the First Amendment of the Constitution of
On the
United
aspect
States.
that wasn't contended in relation to individuals. So
Let
if you
me
look
finish.
through the full case, there was three
At
claims. There was
Title
three
IV
specific
of the
claims
Civil
of
Rights
First
Act,
Amendment
1960.
violations in this case. What were the three specific claims, True? Seeing as you know so much.
We went through this already.
No,
The
we
first
didn't.
one-
No, we didn't. You never named all three claims of the specific violations
Actually,
as free
I did.
speech. No, you didn't. Then name them.
Yes, I did.
It's so easy. Name them.
Ido, are you like sane?
One is the individual level of individual faculty, the second is the protests, and the third is specifically in regards to response and retaliations of the Trump administration and the board of directors and the presidents and fellows of Harvard, because they also try to silence some of the boards in this case. They tried to stop a gag order on them at one point. Guess what? That failed. That's, if you knew anything about this case, you would have immediately stated such. But you didn't.
So Ido, I have a question, right? So clearly you're right about everything and everyone else is just wrong.
You mean people who've never followed this case? Yeah.
No, I don't know
Yeah.
anything about the case. I
Yeah,
don't
yeah.
know
Ido
anything
is
about the
Ido. So wait, Ido. I just want to clear. Can you tell me
An
exactly?
appeal to a majority is a pretty bad
Ido, can you
argument.
tell?
No,
Can you
no,
tell?
I'm not
Ido,
appealing
Ido,
to
can you
the
tell
That is
me?
literally an
Ido,
appeal
can
to
you tell me
majority
the final? Wait,
verbatim.
Ido, what's the final word count of the final judgment? Can you tell me that?
Why would I know a final word count?
What's the word count of the final judgment? No, do you know that?
What? Why would
How
I
many
know that?
periods
That's a
are
dumb
used in
thing.
the final judgment? Have
That's
you
not-
even
wait,
read
wait,
this
wait,
case?
that's not
No.
substantive.
You obviously haven't read
That's
this
not
case. If you don't know the
substantive.
word count, you haven't even read
Wait,
it, bro.
excuse me. That's not
How
substantive.
many words?
The
Wait, how many pages?
The
are-
claimants, the claimants on the First Amendment are substantive to the argument. The word count isn't. That's disingenuous. You're literally being the exact thing you complain about.
That's disingenuous.
He's just doing.
The word
instead
count
of-
isn't substantive to the argument. The claimants of the
just explain-
violations are.
Can you mute this guy?
So not knowing the claimants of the violations is pretty piss poor if you're going to make an argument for it.
Just explain your point. Can you explain it?
I can't with this guy.
Yeah, you're a fucking disingenuous hack.
So,
I made a substantive argument that's a part of the claimant, and you're just going out there and
I just
asking
wanna-
for a word
so,
count.
just
Irrelevant.
Great. So when the court says we're gonna vacate and set aside this order, like what are they telling the government to do with that order?
They're not telling the government to do anything with the order. That's not what they were. What do you think vacating is in this case? They're not telling the government. They are ordering. They are ordering this to be set aside for the proceedings of this case. So in this part, they are ordering the government to stop in this part for this particular period of time while certain things are clarified.
Yes,
that is
because
all
it's
it is.
frozen.
They're not
It's not.
telling the
It's
government
not
they're ordering.
frozen.
How would they-
Frozen is a different concept in legal.
Okay. So
No,
this
you're
is-
using
this
using
is
common
kind of-
nomenclature
this is-
use of frozen
yes,
rather than what the
yes,
court would
that's-
consider.
I have been-
That's
I
not
will-
the same.
So I want to be clear. Sorry, I'm
That's not the same thing.
So, I'm sorry. I'm gonna be honest, right? And we're gonna go through this, and we're gonna make it right. When
What's
I
the
talk,
difference
I'm
then,
not.
Edo?
I'm not. I will be clear to everybody on the panel and everybody in the audience currently. I'm not a lawyer, right? I do not. I will use legal words and concepts of responsibility. I will not always understand. Sometimes use common nomenclature and not understand that has a deeper legal meaning, right? So the problem here is that when I said that the court froze something, I was saying that the court had stopped a certain grant from going through, or certain stop work order from going through for like a certain period of time. Then took that to be the legal meaning, and I think was smart enough to know that I'm obviously not a lawyer, and I was using common nomenclature. So the
You were
point
using it in the quotation of the order itself, so yeah, you should have known what you were talking about. Otherwise, are we talking about the same thing? No.
All right,
evidently not.
Ido, I have a question.
So the point
Are you like smart or like what's your background?
Wait, no, scratch finish.
No,
Scratch
Vader.
finish.
This is 1 second. Vader.
What?
This is the case 125 CV. So this is the specific case in the order in entrance and final judgment. So they entered the final judgment on this case. The secondary case
125
is to do with the
CV
second appeal.
11048.
And it's
Yeah, Vader, he
ADB, which
says
is
that
which is literally under Allison D. Burroughs.
Yeah, Vader, he says that the court didn't adjudicate the First Amendment claim on the APA.
That's not what I said.
That's just
I said
you
they
did.
didn't. I said they didn't adjudicate on all First Amendment claims because there were several made in the case. They adjudicated on one of them, which I agreed to, and which was already in statement because it wasn't under contention. There was agreed upon there was agreed upon during the proceedings on the side of both the United States Department of Health and Human Services
We love you,
and
Coach.
the presidents and fellows of Harvard College that both these cases of First Amendment couldn't be adjudicated because there's complexities in the arguments and therefore should be passed up to a higher court. But on the specific case that they adjudicated on, which was to do with individual rights, so it was to do the individual fellows at Harvard, they won on that one. Nobody was arguing against it though. So when you read into it and you go, "Oh, they did that," because you're asking for a summary of an entire court case, so everybody in the proceedings knows what it's
where it says that.
Oh my God! Oh my God! It's
Ido.
evident if you follow a court case. The court case doesn't.
What is a summary judgment motion?
Ido, just listen for 1 second.
This, I just want to be clear about it.
I'm dealing with a bunch of idiots at this point.
1 second, bro.
Scratch, you
Listen,
said
if
scratch. You're not
Cringy, if
off
Cringy and Evil Poutine are not yelling at the top of their lungs, dude, you've won.
What is a motion for summary judgment?
The motion for some. Wait, what do you mean? What is the motion for summary judgment? What part
is
are you
it?
asking about?
No. Ask just general.
It's
Can you
a compilation of
describe-
the, it's a compilation of the legal arguments that have been put forth to the judge making a summary case using the law, and then addressing those arguments presented to her in the case in respect.
And how is that presented?
It can be presented in several different ways. In the regards to the District of Massachusetts and the United States District Courts, it's usually presented as a pre-finalized summarization of the points and clarifications of the legal status of the arguments.
That's just a bunch of words. Let me ask you.
No, wait, that's not a bunch of words. You're claiming to be a lawyer and you don't understand what was said there? Wait, no. That was a very clear, that was a very clear statement. The legal standard would be the applicable laws in the case.
No, what's the legal standard to win a motion for summary judgment?
What's the legal standard? It depends on the case.
No.
Yes, if you are dealing with different cases, they have different requirements.
Ito's getting Quizlered.
No. How is that getting Quizlers? That's evident in the case. If you are dealing with a case of battery and abuse and it goes to the district level for whatever reason, or you are dealing with a case of financial fraud there's different levels here. A final order motion is just the judge's summary.
Obviously, okay.
Yeah, and he just said they're the same.
No.
Scratch. He just said they're the same.
No. If a plaintiff,
yeah, he did.
Can I finish? If a plaintiff was to file a preliminary injunction, obviously there's, depending on why they're filing, they're gonna have to prove different things, but they're always gonna have to prove irreparable harm, right? So I think that's what True is trying to get at. There's certain things for summary judgment that you're just necessarily always gonna have to prove, correct?
Yeah, what is the simple legal standard for motion for summary judgment?
Except that's not what he's arguing. You just gave the alleged lawyer an argument that isn't what he made.
No.
That isn't the argument you just made. That is not the argument you just made.
That was literally my interpretation.
That was your interpretation of a different thing that he wasn't saying.
That's exactly what he's saying.
That wasn't what he was saying.
There's some basic things you need to
That literally wasn't what he was saying. Because I asked him in clarification on this, and he just said, "Oh, that's a bunch of word salad."
It is.
That isn't. Except it wasn't a bunch of word salad.
You know what?
Yes.
What you have to
answer the question.
What's the legal standard? Do you know at all?
Do I know what the legal standard was specific in this case for the First Amendment violations?
No, for any motion for summary judgment.
But there's different legal standards for summary emotional judgments. Yes, there is.
No, you have to be able to show if there's a triable issue of fact. That's the standard. If there's a triable issue of fact, then you lose the motion for a summary judgment. If there is no triable issue of fact, you win the summary judgment motion. That's for every single summary motion that's ever filed in civil court.
I love how you have to mute me, even though what he's saying is completely factually wrong. Shall we read what that standard is set? Because even Vader's disagreeing with you on this. That's not what the standard is set. There are different levels to this. It's not uniform.
It's a tribal issue of fact. It's the standard.
Vader, go ahead.
Summary judgment, it means there is no issue of fact or there is no matter of law to be discussed, though a trial is unnecessary.
Right.
Thank you. Thank you. And that requires a different burden of proof on each case.
No. A summary judgment is that is the standard. There is only one standard of summary judgment.
No, what he's arguing is the burden of proof that you have to get to the summary judgment. Not the actual summary judgment.
Summary judgment is pre-trial, too.
Yes, I agreed on that. That's why I found it ridiculous. It's the burden of proof to which you have to prove that there is no legality to be argued in a trial. It's not.
Right.
It's not.
There is only one standard of that. You have said multiple times that there's multiple standards.
No. I'm saying there's multiple burdens to reach to get.
Oh my God! What a weasel! Holy shit!
Wait, that's not weaseling. There is. If you are dealing with different cases, the burden in which you have to reach to prove that. Yeah, because you don't know what you're talking about. The burden in which you have to reach to prove that is going to be different dependent on cases. Wait, no. Nothing I'm saying is incorrect here. What you have to prove in these cases will be different based on the claims made.
The
problem is your idiocy. Except I'm not confidently wrong. I'm confidently right. Saying that I'm wrong and arguing from a place of idiocy is not what I was it's not addressing my point. My point is very clear that if you are dealing with different cases, the way you get to the order of summary judgment will not be a uniform linear track. In fact, this judgment just simply states that there is nothing in legal question.
Nobody made that claim.
That is literally what True was arguing.
Nobody says it's a standard linear track.
There is nothing in legal contentional claim to reach that. That's going to be different based on the case that's being drawn. That's literally what he said because I challenged him on it.
He never said that.
And I'm sorry, I'm not going to trust you on like this. You've lied pretty much most of this life.
You have been lying and weaseling through your points the entire
No,
time,
I've been
bro.
arguing the entire point, and I'm dealing with somebody who's ignorant to the case he's talking about.
You're ignorant to the case you're talking about. You thought there was only...
You didn't even know how many free speech violations were brought up in this case.
You didn't even know that. You didn't even know which case we were talking about because they were assigned to different cases. I had to bring it up. I had pointed out to you.
Literally, on the moment we brought up the case, I brought up the case number from the beginning. You liar. You did it again. I pulled it up and showed it on the camera
in chat that agrees
4 times.
You're a pseudo-intellectual hack who doesn't know anything, okay? And
love the projection here, Scratch. How's the Unfuck America tour with the 30 grade
Did I ever claim to be a lawyer? Did I say multiple times? I've admitted to being wrong multiple times in this conversation. I have literally said, admitted 2 seconds ago that I didn't know all of the legal jargon. What are you talking about, dude?
Major crash out.
You've been yelling.
You are arguing on the letter of this motion without understanding, and they're not siding with Scratch because they don't even know Scratch's argument.
Fucking sentence. Turn your gain down. Holy shit, bro. Oh my god.
What game?
Holy.
So okay, thank you. By the way, look, thank you for agreeing with me.
They don't agree with you because they don't hear your argument. If they heard your argument, they think you're a fucking idiot.
Really? Okay, so Vader, do you agree with me that in the case that...
Watch him change his argument now.
I'm asking you, Vader, okay, we all agree. The initial point that I was trying to prove, right, is that Donald Trump had violated the First Amendment rights of Harvard by stopping, like, these, like, grants that Harvard had. Like, there was some of them involving, like, cancer research on the basis of like anti-Semitism, and the court determined that to be the violation of like Harvard's First Amendment rights. That was the initial point that I was trying to prove. In making that point, I also said that the court had frozen.
No,
right?
you've jumped from 5 other points you made in that argument space as well. That was half an hour late. See, I told you you'd be manipulated.
I know what. I never did. What other point?
So you initially made one argument. Wait, no. The claims on the legality of it is what we've been arguing. So if he's going to ask for a lawyer's opinion, if you're going to ask for his opinion on your argument, you're going to have to show him your argument instead of just saying, oh well, this is the main point that I was arguing, and then ignoring all the times that you were wrong. Who's being the snake there? You, because you don't want to admit or show where you made dumbass arguments.
Multiple times.
No. You admitted to being wrong on 2 occasions, and
yes.
that was it.
So 2
most
occasions,
of them, the most
is
minor
2 occasions multiple times? Yes or no?
Yes, in minor respect.
So I admitted to being wrong multiple times.
Wait.
Your bitch ass up.
In the most minor respect. And you really shouldn't be calling anybody a retard when you speak like the way you do.
You should be calling anybody retard. You know the case you're talking about. You didn't know the fuck there's 2 cases.
Yes, yes, I did. You claimed there was 3 cases earlier because it included Allison. But you weren't. We were speaking about a specific part of the case in a specific context. This is the only case relevant to that part of the context.
You were confused because you said that Allison.
This is the only. No.
Allison was only signed to 1 case, and you don't want to admit that.
So I didn't. That's not what I said. I said I could only find Allison assigned to 1 case. Maybe she got reassigned to another case. I literally gave you that argument, so don't lie about what I said either.
That was after I showed you the other case.
Yes, because you were looking at a completely different thing that had nothing to do with it. It was dealing with a different aspect of the arguments being made.
You're lying.
Idiot. You literally admitted
You're
that.
You're such a weasel.
You admitted earlier that you were wrong about that, and now you're going back.
You're not a person. I keep forgetting that. Vader, okay. Holy shit. Don't let him up till I want him up again. Vader, is my opinion correct? Sorry.
I'm gonna have to double check the actual, read the case.
You literally changed it again.
Please.
Who's letting this bitch
This
up?
is what.
I'm sorry. Who?
Only people who have attained the status of person, right? Which means that you have to have some kind of full consciousness, which then means you have well-being under my moral.
I'm way more of a person than you are.
No, you're not, dude. You're British.
Yeah, no. Yeah, you're fucking British.
Holy shit. I'm gonna keep kicking him if they let him up. I don't know who's letting him up. It's because not fucking me.
Sergeant of a COD plus fucking... What? He's like Sergeant of a COD plus like Nick Fuentes or something. I don't know.
Oh my god.
Says the kid who couldn't argue at all in regards to what was on Nick's panel. So
by the way, you have a rogue mod. Scratch, you might want to go through your mod listing and.
I know how you're making ad homs, but you never address the actual point. Because you guys are weak.
Annoying is entertaining himself. Fuck you, dude.